So I have an important update on the California concealed carry ban and the recent action by the Ninth Circuit, which allowed the state of California to outright defy the Supreme Court and put in place a concealed carry ban. So let's talk about what is now happening in this case. But real quick before we jump into this video, if you think the state of California needs to stop violating the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to thank one of the new sponsors of the channel, which is 1st Phorm. A lot of you guys have been commenting and seeing that I've been losing weight. Over this last year, I kind of went on a weight loss journey. And then at the end of the year, I did the 75 Hard program, which is a program from Andy Frisella, the owner of 1st Phorm. A lot of the guys over there at 1st Phorm watch this channel, support the Second Amendment, support this type of freedom content. So they saw me wearing some merch and they wanted to support the channel. So now they're a sponsor. Thank you to 1st Phorm for sponsoring this type of content. And if you guys are looking to get maybe in a little bit more shape this year, check out some of the products that 1st Phorm has. I will link them down below. And again, thank you to 1st Phorm for sponsoring this channel. So as I mentioned in the intro, in this video, I have an important update for everyone that's currently in California and those of us who are currently facing the statewide concealed carry ban. As we talked about in the last video, the Ninth Circuit recently let California fully implement their new concealed carry ban by issuing an administrative stay against the injunction that we won in the lower courts. Because of that administrative stay, at the beginning of this year, it has now become illegal to legally carry a concealed firearm out in public almost everywhere, even though you have a concealed carry permit. So for the millions of California gun owners and concealed carry permit holders, that administrative stay directly stripped away your legal ability to concealed carry even though you had a permit. However, the attorneys over at Michelle & Associates, who are the lead attorneys in this case, are working very hard to get the Ninth Circuit to at least reconsider or clarify what their intent is going forward with this administrative stay and where this case is going to go from here. That Ninth Circuit motion panel who flippantly granted the administrative stay has pretty much left millions of people vulnerable, and the recent motion by Michelle & Associates and the plaintiffs in this case asked for the Ninth Circuit to either cure that issue or clarify what is going on in this case. Now, the case we're talking about in this video, of course, is the May v. Bonta case. This is the case that myself and Reno May joined as plaintiffs to sue the state of California because of the new SB 2 law. Recently, we received a big win when Federal District Court Judge Cormac Carney granted a preliminary injunction against various aspects of California's new CCW restrictions. This case specifically targeted some of those sensitive location restrictions and pretty much the state of California's outright concealed carry ban because they made your permit useless even if you got one. Now, after the injunction, we all knew that the state of California was going to appeal. That's exactly what they did. And they also filed for an emergency stay, and that went to a motions panel. The judges on the motion panel were Judges Rawlinson, Bybee, and Hurwitz, which was not a good makeup of a panel for us. And ultimately what they did is they did grant the state of California an administrative stay on that injunction, which ultimately meant that when the clock struck midnight and the calendar turned over to 2024, well, now California has been able to fully implement SB 2, banning concealed carry in the entire state. Now, one positive thing that I've seen over the last few days after SB 2 went into full effect was that there have been many county sheriffs, many departments, law enforcement agencies that have come out and said that they will not actively enforce SB 2, not only because there is very little clarity on the law itself or its ability to even be implemented or some of the training requirements, but also a lot of these county sheriffs do not agree with this law because it directly violates the Second Amendment. For example, in my immediate area, you have the Fresno County Sheriff's Department and then also Tulare County Sheriff's Department who have made statements publicly that they will not actively enforce SB 2. So there is some good news with various law enforcement agencies making public statements that they're going to stand up against the state, that they're not going to actively enforce SB 2. But still, with this current administrative stay, SB 2 is allowed to be in full force and effect, and without further clarification on what the Ninth Circuit intends to do, we're kind of in this weird limbo stage, and maybe that's what the Ninth Circuit in California wants. Now, in response, Michelle & Associates have filed for a motion for reconsideration or clarification of the current motions panel's administrative stay. In this motion that was filed, it states that SB 2 was enacted in response to the United States Supreme Court's landmark ruling that recognized a general right to publicly carry arms for self-defense. SB 2 thus represents California's attempt to defy the U.S. Supreme Court, and it, not the district court's preliminary injunction, interrupts the status quo ante of where people with carry permits can exercise the right to armed self-defense. California's defiance includes a plan to lure this court into treating the Second Amendment as a disfavored right, but doing so would gut the right of self-defense and put people's lives in danger. That is the urgency that attends this state's motion for a stay. That is the reason this motion must be addressed in haste. The text of the administrative stay order from the motions panel is somewhat unclear about what happens next and when. This motion seeks urgency and clarity from the court. From the constitutional law perspective, the position that plaintiffs find themselves in because of the administrative stay, allowing SB2 to go into effect, is no different than if the state had passed a law banning protests in most public spaces. Despite a district court agreeing that such a law upset the status quo of allowing peaceful public protest and inflicted a grave First Amendment injury on hundreds of thousands of citizens, protests against an unpopular war or a corrupt politician would then nonetheless be put on hold for months or longer while the state's emergency stay motion defending the law received more vetting by the appellate court. Such a pause on hundreds of thousands of people's exercise of the right to free speech, even for administrative reasons, would obviously be patently unacceptable. That the same sort of pause on the Second Amendment right is now being entertained in this case lends unfortunate credence to concerns that despite the Supreme Court's unambiguous holding to the contrary, the Second Amendment is still considered a second-class right in this circuit. Plaintiffs/appellees therefore seek clarification of whether this matter is still subject to a months-long briefing schedule before the district court's injunction might be allowed to take effect, or whether the transfer of the state's emergency stay motion from the motions panel to the merits panel will take place on a more appropriate expedited schedule in light of the constitutional injury presently inflicted. Through this motion, what is first being asked is that the motions panel reconsider their administrative stay and immediately dissolve it to restore the status quo of concealed carry rights in California, which existed prior to January 1st. Because remember, SB2 going into effect completely changed the laws and changed the status quo. Now, in the alternative, what is being asked is for the Ninth Circuit to immediately send the case to a merits panel, and for that assigned merits panel to quickly rule and resolve the state's emergency stay motion. In simplest terms, this motion is asking for the Ninth Circuit to get off their butts, to do something, and at the very least clarify what is the status of this case. This is absolutely needed so that the attorneys of this case can decide what they need to do going forward to try to stop SB2. The effort right now is to essentially prevent this case from being stuck in a perpetual limbo status of an administrative stay and prevent the Ninth Circuit from just doing nothing. What needs to be clarified is if this case has been assigned to a merits panel and if it's going to be maybe assigned going forward, kind of who has control of this issue right now. And if this issue in this case has been sent to the merits panel, what is going to happen? Are they going to decide, and are they currently reviewing the emergency stay, and are they going to issue a decision on that request? So hopefully here in the next few days, we will get some more information on what the Ninth Circuit intends to do, what's the status of this case, and maybe what can happen going forward, and kind of some of the relief that can be sought because of the status of the case. If the Ninth Circuit is going to allow SB2 to sit and take no immediate action on this case, well, then there's always the option to try to elevate a request to maybe the Ninth Circuit en banc panel or maybe even the Supreme Court. Now, I have no say on the strategy of this case. I want to be absolutely clear. I have no idea of what the attorneys intend to do in this case, but I do know this motion is asking for clarity. They're asking for maybe a potential reconsideration or of course, a dissolution or a dissolving of the current administrative stay, but at the very least, some clarity so they can decide what they need to do going forward. Personally, I think the Ninth Circuit intends to slow walk this case and allow the concealed carry ban to remain in place for as long as possible. The Ninth Circuit has openly defied the Supreme Court multiple times and most recently broke their own rules to take the California Duncan v. Bonta magazine ban case as a comeback case. And because of them breaking their rules and taking the Duncan case, they prevented Judge Benitez and his decision, which struck down the magazine ban from going into effect. Now, I also want to state, I think a lot of this is a product of the Supreme Court not stepping in recently in these 2A cases, and especially in these 2A defiance cases. After Bruin, the Supreme Court had multiple opportunities to place checks on various states and lower courts and their defiance of what they said in Bruin, but the Supreme Court refused to step in those cases. But right now, there is a motion which is not only seeking to override the administrative stay and override SB2, but also that motion is seeking additional clarity so that some of the strategy can be determined going forward, and so we know what's actually going on in this case instead of it just sitting in a limbo stage. Again, spread this video around to anyone in California, anyone who is interested in maybe concealed carry in California or just California gun owners at large. But if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and it signals to YouTube that you guys see value in these videos in this type of 2A news. As always, thank you guys so much for if you're liking, commenting, subscribing, or sharing these videos. That directly impacts these videos, impacts this channel, and helps me to reach and educate more people than I could ever do on my own. But regardless, thank you guys so much for all of your support. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.